Before we begin, a quick and important disclaimer. The information presented in this video is strictly for educational and entertainment purposes only and does not constitute professional, legal, financial, or tax advice. The complexities of family law, asset division, and macroeconomic trends are highly specific to individual circumstances and state jurisdictions. Do not make any personal, legal, or financial decisions based solely on the content of this video. We strongly advise all viewers to conduct their own due diligence and consult with licensed legal counsel and certified financial professionals regarding their specific situations. Historical trends and case studies discussed here are illustrative and do not represent expected outcomes for any specific legal proceedings. You have probably been told your entire life that financial stress is the #1 cause of divorce. We picture couples fighting at the kitchen table over past due bills, maxed out credit cards, the threat of foreclosure, and the crushing weight of an economic recession. But what if I told you that some of the most brutal, complex, and systematic wealth-destroying divorces in American history do not happen when the market crashes? They happen when the market is booming. Consider the counterintuitive phenomenon experienced by top-tier family law attorneys during peak economic cycles. When the United States economy enters a massive bull run, when the stock market reaches unprecedented, all-time highs, and when home equity swells to the point of turning average middle-class families into paper millionaires overnight, the fundamental dynamics of marriage and separation experience a radical shift. It is a psychological and financial reality that most people never see coming. During recessions, couples often hunker down. They stay together out of sheer financial survival, sharing expenses because they simply cannot afford to liquidate their deeply depreciated assets or maintain two separate households in a terrible economy. They are trapped by negative equity. But when an economic boom hits, a massive surge of liquidity enters the picture. Suddenly, the financial chains holding a fractured, fragile marriage together evaporate completely. There is now enough money, enough equity, and enough projected future wealth to comfortably fund two separate lives, and the floodgates open wide. This is what legal professionals refer to behind closed doors as the liquidity divorce spike, and it creates a highly lucrative frenzy within the legal sector. Imagine the roaring 1990s dot-com bubble, the mid-2000s housing surge, or the explosive post-pandemic asset boom of the early 2020s. In these specific historical windows, United States divorce attorneys did not just see a predictable rise in the sheer volume of cases. They witnessed a staggering mutation in the anatomy and complexity of those cases. They stopped being simple, straightforward arbitrations over who keeps the leased minivan in the joint checking account and transformed into high-stakes, corporate-level legal warfare. We are talking about ferocious, protracted battles over unvested restricted stock units, complex cryptocurrency portfolios hidden across decentralized cold storage wallets, soaring commercial and residential real estate portfolios, and private business valuations that have seemingly doubled or tripled in a matter of months. The financial stakes become astronomically high. One spouse looks at the exploding brokerage account or the soaring valuation of their partner's startup and makes a calculated decision. They want to cash out their 50% at the absolute top of the market cycle before the bubble bursts. And the role of the divorce attorney? During an economic boom, the high-end divorce attorney is no longer just a standard legal representative filing paperwork. They are forced to become a forensic accountant, a private investigator, a complex tax strategist, and a relentless wealth extractor, all rolled into one highly compensated professional. I am going to reveal a highly guarded perspective on exactly how the elite legal class operates when trillions of dollars of American wealth are up for grabs during a euphoric market. By the end of this deep dive, you will understand a fundamental truth that most people tragically ignore until it is entirely too late. The most dangerous time for your accumulated assets is not necessarily when you are actively losing money, but when you are making it faster than you ever thought possible. This brings us to exactly what we are going to unpack today, and why this specific knowledge is absolutely critical for you to absorb, regardless of your current relationship status, your age, or your current net worth. The problem the average American faces right now is a severe and systemic lack of financial and legal literacy regarding how rapidly appreciating assets are handled in the eyes of the family court system. You might be diligently building your wealth, dollar cost averaging into your retirement accounts, scaling a small business, or finally seeing massive equity in your primary residence after years of disciplined mortgage payments. But what you likely do not realize is exactly how vulnerable those very assets become during periods of intense economic expansion, if the legal structures surrounding them are not perfectly fortified and understood. We are going to completely dismantle the romanticized, simplified Hollywood version of divorce and replace it with the cold, hard strategic reality of high net worth asset division during massive bull markets. In this comprehensive exploration, we will analyze the precise historical trends and specific, detailed case studies that reveal the exact tactical maneuvers employed by top-tier legal teams when the economic pie is expanding. We will deeply examine the concept of sudden wealth syndrome and how it acts as a highly volatile catalyst for marital dissolution. When a business owner suddenly receives a massive, life-changing buyout offer from a private equity firm, or when a tech employee's stock options finally vest during a highly anticipated initial public offering, the resulting psychological friction almost always spills over into the legal arena. You will learn the profound mechanical and strategic differences between community property states like California and Texas versus equitable distribution states like New York and Florida, and how those specific legal frameworks are weaponized by attorneys when billions of dollars in new wealth are suddenly created. Furthermore, we will investigate the fascinating, opaque, and complex world of forensic accounting. We will examine the meticulous step-by-step investigative methods used to uncover deliberately hidden assets, offshore asset protection trusts, and complex shell corporations that are intentionally designed to shield newly acquired wealth from a departing spouse. We are not just talking about billionaires or ultra-high net worth individuals here. We are talking about the upper middle class, the local small business owners, the dual-income corporate professionals, and the independent contractors who suddenly find their household net worth ballooning due to highly favorable macroeconomic tailwinds. We will analyze the distinct, aggressive strategies attorneys use to value highly subjective, intangible assets during an economic boom. How exactly does a court divide a fast-growing business whose current value is based entirely on future revenue projections that are currently highly inflated by a euphoric, irrational stock market? What happens when one spouse desperately wants to retain the rapidly appreciating family home to ride the real estate wave, while the other spouse wants to force an immediate liquidation to capture the peak market value in cash? These are the exact, high-conflict scenarios that paralyze the family court dockets and significantly enrich the legal establishment during periods of economic prosperity. By thoroughly understanding these underlying mechanisms, you gain the invaluable ability to foresee potential vulnerabilities in your own financial architecture. Whether your ultimate goal is to protect your hard-earned wealth from future litigation, to deeply understand the macroeconomic shifts that directly influence legal outcomes in this country, or simply to peer behind the curtain of one of the most lucrative, secretive, and cutthroat sectors of the American legal system, this retrospective will provide you with a profound and necessary level of clarity. You will walk away with a highly sophisticated understanding of how capital accumulation, state law, and human psychology violently intersect when the United States economy is running white-hot. This is about removing the blindfold and seeing the economic and legal machine for what it truly is. To fully comprehend this phenomenon, we must step directly into the mechanics of this machine by examining the psychological and financial triggers that ignite these high-asset separations. When a massive economic expansion occurs, such as the market dynamics we are observing in the current year of 2026, wealth creation is rarely distributed evenly within a household. Instead, we see the emergence of asymmetrical asset appreciation. This means that while the household net worth is exploding, the actual source of that new wealth is heavily concentrated in the hands, the career, or the specific investment vehicle of only one spouse. This asymmetry acts as a profound destabilizing force. The spouse generating the rapid wealth begins to feel a sense of absolute financial independence, while the other spouse simultaneously recognizes that their standard of living is now intrinsically tied to volatile assets they do not directly control. The divorce attorney capitalizes on this exact friction. They understand that in a booming economy, they are not just dividing past earnings. They are litigating the future potential of highly speculative assets. Let us examine a highly specific case study reflective of historical trends in the technology sector. Imagine a professional named Mark, an early-stage engineer at a rapidly scaling artificial intelligence firm, and his spouse, Jessica, who supported the household during the lean startup years. For a decade, they lived on a modest base salary, while Mark accumulated a massive portfolio of restricted stock units and complex performance-based stock options. During a stagnant economy, these unvested shares are essentially illiquid lottery tickets, often ignored or undervalued in a standard separation. However, during a furious bull market, the company announces an initial public offering. Overnight, those unvested shares represent tens of millions of dollars in projected future wealth. If they separate during this exact window of euphoria, Jessica is not going to walk away with half of the checking account. Her legal team will initiate a scorched earth campaign for those unvested shares. This is where the elite divorce attorney transforms into a highly specialized financial analyst. The legal battle over unvested equity during an economic boom is a masterclass in complex mathematics and state-specific case law. Attorneys utilize intricate formulas, commonly referred to in legal circles as the time rule, to determine exactly what fraction of those future shares belongs to the marital estate. They calculate the exact number of months the couple was married between the date the options were granted and the date of separation, dividing that by the total number of months between the grant date and the date the stock actually vests. But the warfare does not stop at simple division. The attorney representing the wealth-holding spouse will aggressively argue that the future value of that stock relies entirely on their continued, post-separation labor, arguing that the exiting spouse has no right to value created after the marriage ends. Conversely, the opposing legal team will argue that the foundational effort required to earn those shares occurred entirely during the marriage. They are fighting over millions of dollars of phantom wealth that has not even fully materialized, and the legal fees associated with these specific equity battles can easily reach into the hundreds of thousands of dollars. Now, let us pivot from the digital wealth of the technology sector to the physical, deeply entrenched wealth of the real estate market. Consider the historical trends of housing booms and how they create an entirely different, highly illiquid crisis. Imagine a scenario involving a couple, Robert and Emily, who aggressively acquired a portfolio of suburban residential properties over 15 years. During a macroeconomic expansion, institutional capital floods the housing market, driving the valuation of their specific portfolio up by 300% in a remarkably short period. On paper, they are incredibly wealthy. In reality, their wealth is trapped in bricks and mortar. When a divorce is initiated at the absolute peak of this real estate cycle, it creates a massive liquidity trap. Emily may wish to retain the income-producing properties, but in order to execute a legal buyout of Robert's 50% equitable share, she requires millions of dollars in liquid capital that the couple simply does not possess. In this scenario, the divorce attorneys orchestrate a sophisticated, high-stakes battle of forensic appraisals. The attorney representing the spouse who wishes to retain the real estate will hire an appraiser instructed to identify every single vulnerability in the portfolio. They will highlight deferred maintenance, aggressively forecast potential cooling trends in the local housing market, and emphasize the massive future capital gains tax liabilities that will eventually be owed, all in a coordinated effort to artificially depress the current valuation and lower the required cash buyout. The opposing attorney, representing the spouse who wants to liquidate and exit, will hire a competing appraiser who utilizes the most aggressive, peak market comparable sales data available, demanding a buyout figure that reflects the absolute top of the economic bubble. The court is then forced to arbitrate between two wildly divergent realities, often resulting in the forced liquidation of the entire portfolio just to satisfy the settlement, generating massive transactional fees for brokers, tax burdens for the couple, and substantial billable hours for the legal teams. Imagine if you are the sole owner of a thriving logistics and supply chain business. In 2026, due to favorable macroeconomic tailwinds and a surge in global trade, your revenue is up 40% year over year. But as a seasoned business owner, you understand this growth is an anomaly, a temporary spike caused by an overheated economy. Your spouse files for divorce. Their legal representation hires a forensic business valuation expert who looks exclusively at this temporary, euphoric spike in revenue. They use an income-based valuation approach, projecting your current, inflated earnings out over the next 10 to 15 years, applying a low discount rate due to the booming market, and ultimately valuing your private business at a staggering, unreasonable premium. They are legally demanding half of a number that is built entirely on the fragile, highly dangerous assumption that the current economic boom will last forever. You are no longer just fighting your spouse. You are forced to legally defend yourself against the irrational exuberance of the broader economy. The legal strategies we have discussed so far revolve around battling over the highly visible, easily identifiable assets that swell during an economic boom. The attorneys fight over the primary residence, the brokerage accounts, and the business valuations that are out in the open. But the true, highly guarded masterclass in high net worth divorce during an economic expansion is not about fighting over what is clearly visible on the table. It is about understanding the incredibly dark, sophisticated mechanics of what has been quietly, systematically moved completely out of sight. What happens to a family court proceeding when millions of dollars in newly minted, boomtown wealth mysteriously evaporate into a labyrinth of complex offshore entities and impenetrable legal structures just weeks before the divorce papers are officially filed. To understand the true nature of this high-net-worth legal warfare, we must plunge directly into the dark arts of asset obfuscation. During a massive economic expansion, the most sophisticated wealth creators do not simply walk into a courtroom and argue over the valuation of their visible assets. Instead, they actively construct an elaborate, meticulously planned illusion of poverty, when the broader market is saturated with capital and liquidity is at an all-time high. Hiding that wealth becomes a full-time, highly strategic operation. The overarching goal is not to win the negotiation, but to make the other spouse believe there is absolutely nothing left to negotiate over. This is where the divorce attorney ceases to be a mere litigator and becomes a commander orchestrating a defensive financial retreat. Let us examine a precise, highly realistic scenario reflective of current historical trends. Imagine a character named David, a highly successful commercial real estate developer operating in the robust economic environment of the year 2026. The commercial sector in his region is experiencing a massive, unprecedented renaissance. David's net worth is skyrocketing on paper. However, David knows his 10-year marriage to his spouse, Sarah, is catastrophically failing. Long before any legal paperwork is ever filed with the state, David initiates a highly coordinated strategy of asset dissipation. He does not just move money into a different bank account, he creates a labyrinth. David sets up a series of anonymous limited liability companies in states known for extreme corporate secrecy, such as Delaware or Wyoming. He then creates complex, fictitious consulting contracts and management agreements between his highly profitable primary development firm and these newly minted, entirely empty shell entities. Step by step, massive streams of legitimate, boom-time revenue are quietly diverted away from the marital estate and reclassified as necessary business expenses. To Sarah, who has historically trusted the financial trajectory of the household, and to the naked eye of a standard family court judge, David's primary business suddenly looks like it is struggling with overhead costs, despite the fact that the broader 2026 economy is booming. But domestic shell companies are considered amateur hour for the ultra-wealthy. To truly shield massive capital injections from a departing spouse, legal teams look beyond the borders of the United States. Let us escalate David's scenario. In a booming market, David liquidates a massive commercial property at the absolute peak of the cycle, generating tens of millions of dollars in sudden cash. Instead of depositing this into a joint domestic account, David utilizes historical trends favored by the ultra-rich and establishes an offshore asset protection trust in a jurisdiction renowned for its impenetrable privacy laws, such as the Cook Islands or Nevis. He transfers the liquid capital into this trust, officially naming a foreign entity as the trustee. Legally speaking, David intentionally divests himself of the ownership of his own money. When Sarah finally files for divorce and her legal team demands her equitable 50% share of the profits from that massive property liquidation, David's attorneys simply shrug. They produce documentation proving the money is gone, held by a sovereign entity completely outside the jurisdiction and reach of the American judicial system. A United States family court judge cannot simply compel a foreign trustee in the Cook Islands to wire the money back to a courthouse in Texas or California. This is precisely the moment the divorce attorney deploys their most expensive, devastating weapon, the forensic accountant. During a peak economic boom, top-tier forensic accountants are booked out for months. They are not standard bookkeepers preparing tax returns. They are financial bloodhounds specifically trained to dismantle corporate espionage. When millions of dollars mysteriously vanish, the forensic accountant initiates a brutal, exhaustive process known as a lifestyle analysis. They systematically reconstruct the entire financial reality of the marriage from the ground up. They subpoena credit card records, analyze metadata in digital ledgers, track global wire transfers, and cross-reference known household expenditures against reported income. How do they actually break the illusion? The forensic accountant looks for anomalies that violently contradict the current macroeconomic reality. If the broader market is up 30%, but David's highly positioned development firm is suddenly reporting a suspicious 20% operating loss, the forensic accountant knows exactly where to dig. They begin hunting for classic wealth-hiding maneuvers. They look for deliberate overpayments to the Internal Revenue Service. This is a remarkably common tactic where a wealth-holding spouse intentionally overpays their estimated quarterly taxes by hundreds of thousands of dollars, effectively using the federal government as a highly secure, temporary, hidden savings account. Their plan is to simply claim the massive refund or apply the credit to future tax years, long after the divorce settlement is completely finalized. The forensic accountant also searches for sudden, unexplained conversions of liquid wealth into untraceable physical assets, such as high-end art, rare collectibles, or luxury timepieces that can easily be placed in a safety deposit box and forgotten during the asset disclosure phase. Furthermore, here in 2026, the battleground has permanently shifted to the ultimate frontier of asset obfuscation: decentralized digital networks. Imagine a scenario where a spouse systematically funnels hundreds of thousands of dollars in marital funds into privacy-focused cryptocurrencies, immediately moving those digital assets off centralized exchanges and into a secure, offline hardware wallet. There is no monthly bank statement mailed to the primary residence. There is no corporate server for a judge to subpoena. If the wealth-holding spouse simply memorizes the specific 12-word recovery seed phrase, that substantial fortune is practically invisible to the physical world. The forensic accountant must execute advanced blockchain analytics, searching desperately for the initial fiat on-ramps. They must find the exact historical moment the marital funds left a traditional, regulated banking institution to purchase the digital currency, and then use that undeniable transaction record to force the opposing spouse under oath to account for the missing capital. The emotional and financial toll of this aggressive discovery process is staggering. The legal fees explode exponentially. A standard high-asset case that could have potentially been mediated and settled for $50,000 in legal fees suddenly balloons into a massive, $500,000 war of attrition. This is because the disadvantaged spouse is forced to spend staggering sums of borrowed money just to locate the marital estate before they can even attempt to divide it. The offending spouse relies entirely on this financial drain, hoping their partner will simply run out of capital, become psychologically exhausted, and surrender the hunt. It is a brutal, high-stakes game of financial chicken played at the absolute peak of the economic cycle. But tracking down the hidden millions, mapping the offshore trusts, and successfully deciphering the blockchain ledger is only half of the war. What happens when the forensic accountant actually succeeds? What happens when they finally corner the deceitful spouse, lay out the undeniable step-by-step proof of hidden wealth before a furious family court judge, and the judge prepares to issue a devastating legally binding order to divide those newly discovered assets? You might logically assume this is the definitive moment where justice is served and the hidden wealth is immediately redistributed. But during a euphoric economic boom, the wealthiest individuals have one final nuclear option perfectly prepared years in advance: an ironclad legal mechanism that can render all of that expensive forensic accounting completely useless and leave the exiting spouse with absolutely nothing. That ironclad legal mechanism is the prenuptial agreement, alongside its far more deceptive and strategically weaponized counterpart, the postnuptial agreement. When most people hear the term prenuptial agreement, they rely on an outdated, highly romanticized Hollywood trope. They picture a billionaire octogenarian protecting a vast family fortune from a naive 20-something before walking down the aisle. But in the current macroeconomic climate of 2026, where massive wealth generation is occurring at breakneck speeds across technology, decentralized finance, and artificial intelligence sectors, that stereotype is fundamentally dead. Today, the modern prenuptial agreement is not just a defensive shield for old money. It is an aggressive, forward-looking containment field designed to strictly quarantine future wealth generated during an explosive economic boom. Top-tier family law attorneys do not just draft these contracts to protect what already exists on the day of the wedding. They draft them to completely override and short-circuit the default family laws of the specific state, intentionally opting out of the legal systems designed to protect the lesser-earning spouse. Let us examine a highly specific scenario based on historical trends in startup valuations. Imagine a young founder named James and his partner Chloe. They marry in 2016. At the time of the wedding, James owns a fledgling software engineering firm with zero revenue, operating out of a leased apartment. They sign a standard prenuptial agreement. Fast forward to the year 2026. The broader economy has entered a massive expansion phase, and James has successfully positioned his company at the forefront of the artificial intelligence boom. The business is suddenly valued at $800 million. The couple files for divorce. Chloe inherently assumes that because this massive wealth was entirely generated during the exact years they were married, while she managed the household and raised their children, she is legally entitled to an equitable share of that $800 million valuation. This is the exact moment the trap springs shut. The elite attorneys representing James will calmly produce the decade-old prenuptial agreement. Within its densely drafted pages, buried under layers of complex legal terminology, is a specific clause that categorizes all future appreciation, future income, and future equity distributions of James and his specific company as sole and separate property. The contract explicitly waives any right Chloe might have had to active appreciation, regardless of how much the macroeconomy boosted the business, and regardless of how much domestic labor she contributed to the marital estate. The forensic accounting we discussed previously becomes completely irrelevant. It absolutely does not matter if the forensic accountant locates offshore accounts or hidden crypto wallets, because the prenuptial agreement legally dictates that all of those newly discovered assets belong exclusively to James. The contract acts as an impenetrable wall, effectively severing Chloe from the massive economic boom she lived through. But what if the couple never signed a prenuptial agreement before the wedding? This leads us to one of the most ruthless, psychologically manipulative tactics utilized in high-asset family law during a rapid economic expansion: the strategic deployment of the postnuptial agreement. A postnuptial agreement is essentially the exact same contract, but it is negotiated and signed in the middle of the marriage. You must ask yourself a critical question. Why would any rational spouse willingly sign away their legal rights to billions of dollars of future marital wealth years after the wedding has already taken place? They do it because the document is almost never presented to them as a divorce planning tool. It is presented as an urgent, unavoidable business necessity. Imagine another scenario. Consider William, a highly aggressive venture capitalist, and his spouse Amanda. The year is 2026, and the markets are overflowing with institutional liquidity. William is on the verge of launching a massive new investment fund that has the potential to generate hundreds of millions of dollars in carried interest and management fees. He returns home and presents Amanda with a highly complex postnuptial agreement. He does not frame this as a precursor to divorce. Instead, he utilizes the complexity of the economic boom against her. He claims that his new institutional investors, the massive pension funds and sovereign wealth funds backing his new venture, require absolute legal certainty. He argues that these investors refuse to risk their capital if William is exposed to a potentially catastrophic future divorce settlement that could theoretically freeze the assets of the entire investment firm. He tells Amanda that in order to protect their family, to secure this massive generational wealth, and to satisfy the strict liability requirements of his corporate partners, she must sign the document legally separating her from the management company. Believing she is acting in the best financial interest of the family unit, and trusting the trajectory of the marriage, Amanda signs the postnuptial agreement. She legally waives her right to the future explosive growth of the fund. 3 years later, when the fund hits its peak valuation and the wealth has been entirely secured, William files for divorce. Amanda is suddenly faced with the horrifying reality that she voluntarily signed away her legal right to half of a financial empire. The legal drafting of these specific mid-marriage contracts is a meticulous art form. Attorneys will include sweeping waivers of spousal support, strict caps on equitable distribution, and severability clauses designed to ensure that even if a judge strikes down one specific paragraph of the contract, the rest of the wealth-shielding mechanisms remain perfectly intact. They use the momentum and the sheer complexity of the economic boom to overwhelm the lesser-earning spouse, turning a moment of extreme financial success into an invisible legal prison. This is the cold reality of the legal machine. It operates on the absolute letter of the contract, not the emotional fairness of the relationship. When trillions of dollars are circulating in a white-hot economy, verbal promises, assumed partnerships, and the general concept of fairness are completely eradicated by a properly executed legal document. The attorneys orchestrating these maneuvers are highly compensated precisely because they understand how to project macroeconomic trends years into the future and draft contracts that capture all of the upside for their specific client, while completely insulating them from the financial risks of a failed marriage. But this raises a profound, highly volatile question that strikes absolute terror into the hearts of the wealth-holding class. If these prenuptial and postnuptial agreements are truly designed to be impenetrable fortresses of wealth protection, are they actually invincible? What happens when a severely disadvantaged spouse, staring down the barrel of total financial ruin during an unprecedented economic boom, refuses to accept defeat? The legal battle does not end with the presentation of the contract. In fact, that is merely the opening salvo, because in the high-stakes arena of elite family law, There is a specific, highly destructive legal pathway to absolutely obliterate these ironclad agreements, completely invalidating the contract and throwing the entire multi-million-dollar marital estate back into absolute chaos. The legal strategy to systematically dismantle a prenuptial or postnuptial agreement does not begin by arguing that the contract is simply unfair. Family court judges are not particularly interested in emotional fairness when two consenting adults have deliberately signed a legally binding document. Instead, elite divorce attorneys target the foundational integrity of the contract itself. They must prove to the court that the circumstances under which the agreement was executed were fundamentally flawed, deceptive, or coercive. This highly specialized legal warfare is categorized into three primary avenues of attack: procedural duress, substantive unconscionability, and the absolute most lethal weapon in the legal arsenal, material non-disclosure. When an explosive economic boom creates hundreds of millions of dollars in unexpected, unprecedented wealth, the financial incentive to completely blow up these contracts becomes astronomical. Legal teams will gladly spend thousands of highly expensive billable hours meticulously investigating the exact days, hours, and minutes leading up to the original signing of the document. Let us first examine the concept of procedural duress and the critical vulnerability of timing. The timeline surrounding the execution of a prenuptial agreement is heavily scrutinized by the court. Imagine a potential outcome involving a prominent corporate executive named David and his fiancée, Elizabeth, who are set to marry in the summer of 2026. David holds a massive, rapidly appreciating portfolio of commercial real estate. His legal team drafts an incredibly aggressive prenuptial agreement designed to completely wall off this growing empire from the marital estate. However, instead of presenting this complex document to Elizabeth several months in advance, allowing her ample time to hire independent legal counsel, thoroughly review the terms, and negotiate a fair outcome, David intentionally waits. He waits until 48 hours before the massive destination wedding ceremony. The expensive invitations have long been mailed, hundreds of influential guests have booked international flights, the luxury venue is entirely non-refundable, and the social pressure is at an absolute, suffocating apex. He casually drops the dense, 60-page legal document on the table and states that the wedding will simply not proceed unless she signs it immediately. In the current legal landscape, this deliberate orchestration of extreme psychological pressure is a massive, fatal vulnerability. When the marriage eventually collapses during a peak economic cycle, and the commercial real estate portfolio is now worth quadruple its original value, Elizabeth's attorneys will not waste their time attacking the valuation of the specific buildings. They will fiercely attack the timeline. They will subpoena every single email, text message, and digital communication between David and his original drafting attorney, hunting for digital proof that they intentionally delayed the presentation of the document as a ruthless tactical negotiation strategy. They will argue procedural duress, claiming Elizabeth was essentially held legally hostage and completely deprived of her fundamental legal right to meaningful, independent representation. In specific jurisdictions like California, family law specifically mandates a strict 7-day waiting period between the final presentation of the agreement and the actual signing. If David's attorneys violated that strict waiting period by even a matter of a few hours, the entire contract, and its absolute protection over the multi-million-dollar real estate empire, can be completely invalidated by a judge. However, proving duress is heavily reliant on subjective human memory, witness testimony, and emotional context. The far more clinical, devastating, and historically successful method for destroying these wealth-shielding contracts is proving material non-disclosure. A prenuptial agreement is fundamentally a legal exchange of information. In exchange for one spouse voluntarily waiving their future rights to the marital estate, the other spouse is legally and ethically mandated to provide a complete, transparent, and surgically accurate disclosure of every single asset, liability, and stream of income they possess at the exact time of the signing. There is absolutely zero margin for error. Elite family law attorneys deeply understand that if they can find one single, materially significant financial omission on that original disclosure schedule, they possess the power to detonate the entire contract. Consider a highly illustrative case study based on historical trends in the technology sector. Imagine a software developer named Christopher who signs a prenuptial agreement with his partner, Rachel, in the year 2018. Christopher attaches a mandated financial schedule detailing his current bank accounts, a modest retirement fund, and a leased vehicle. The contract explicitly states that all of Christopher's premarital property, and any future economic growth of that property remains his sole and separate asset. However, Christopher deliberately chooses to omit a highly speculative, highly illiquid angel investment he made in a colleague's obscure technology startup 2 years prior, genuinely believing it to be essentially worthless at the time of the marriage. Fast forward to the year 2026. The macroeconomic environment has experienced a massive, unprecedented expansion. That once obscure startup is now a publicly traded artificial intelligence powerhouse, and Christopher's previously hidden, forgotten angel shares are suddenly worth $75 million in highly liquid capital. When the divorce proceeding is officially initiated, Rachel's elite forensic accountants immediately launch a comprehensive, scorched earth audit of Christopher's entire historical financial footprint. Through meticulous tracking, they discover the original wire transfer from 2016 that initially funded the angel investment. They forcefully cross-reference that undeniable financial transaction with the signed disclosure schedule physically attached to the 2018 prenuptial agreement. The asset is entirely missing. Rachel's legal team immediately files a massive legal motion to void the entire contract based on fraudulent material non-disclosure. They compellingly argue to the family court judge that Rachel could not possibly have made an informed, legal decision to waive her rights to Christopher's future wealth because Christopher deliberately concealed the true nature, existence, and future potential magnitude of that wealth. If the presiding judge agrees that the omission was material to the signing of the document, the prenuptial agreement is instantly shredded. The impenetrable protective wall evaporates into thin air, and that newly discovered $75 million windfall is suddenly reclassified as community or marital property subject to immediate equitable division. A single calculated lie of omission on a piece of paper from 8 years ago becomes the direct catalyst for one of the largest, most violent wealth transfers of the entire economic boom. Finally, if the contract survives the attacks on duress and non-disclosure, attorneys will relentlessly utilize the legal doctrine of substantive unconscionability. This legal theory powerfully argues that even if the contract was signed without any psychological pressure, and even if every single asset was perfectly and accurately disclosed, the resulting financial outcome is so brutally disproportionate, so deeply offensive to basic legal standards of human decency, that the court simply cannot enforce it. This theory is highly relevant and frequently deployed during unprecedented economic booms. Imagine a specific scenario where a post-nuptial agreement was signed when a family business was struggling and valued at merely $1 million. 10 years later, strictly due to a massive unforeseen macroeconomic expansion, the business is suddenly valued at $2 billion. The wealthy spouse is generating $50 million a year in passive dividend income, while the contract mathematically dictates that the exiting spouse, who has been entirely out of the workforce raising children for a decade, receives a strictly capped, single lump sum payment of $50,000 and absolutely zero ongoing spousal support. Courts across the United States have a fundamental, deeply ingrained public policy interest in actively preventing recently divorced individuals from immediately becoming financial dependents of the state welfare system, while their former partner lives in unfathomable billionaire-tier luxury. When the economic disparity created by the boom reaches this level of absolute extremity, the disadvantaged spouse's legal team will aggressively argue that enforcing the literal terms of the contract is fundamentally unconscionable. They will force the wealth-holding spouse to sit for a grueling, highly combative, multi-day legal deposition. Under oath, and under the intense scrutiny of a high-definition video camera, the attorneys will completely dissect the wealthy spouse's extravagant, post-separation lifestyle. They will meticulously contrast the private jets, the massive real estate acquisitions, and the staggering liquidity with the catastrophic poverty the contract attempts to force upon the other spouse. It is a highly calculated, brutal strategy of legal pressure, designed to force a massive, private, off-the-record financial settlement long before the judge ever has the opportunity to rule on the contract's actual technical validity. Once the legal fortification of the prenuptial agreement is successfully breached, or if one never existed in the first place, the legal warfare violently shifts entirely to the ultimate, most complex battlefield of the modern economic boom. The wealth is no longer hidden in offshore trusts, and it is no longer protected by an ironclad contract. But the staggering wealth generated in 2026 is rarely sitting neatly in a simple joint checking account waiting to be effortlessly split in half by a judge. What happens to the legal process when the defining, massive assets of the marriage are incredibly complex, highly illiquid mechanisms of corporate control, such as restrictive executive stock options, non-transferable carried interest in private equity funds, and intricate phantom equity plans that literally cannot be legally divided or transferred without triggering massive, crippling tax penalties and violating strict corporate governance laws. This is where the high-net-worth divorce transitions from a complex legal dispute into a high-stakes corporate restructuring event. In the unprecedented economic climate of 2026, the apex of wealth creation is rarely found in simple checking accounts or standard, publicly traded brokerage portfolios. The true, astronomical fortunes are locked inside restricted, highly sophisticated corporate compensation vehicles. When a divorce attorney encounters unvested restricted stock units, performance shares, or private equity carried interest, they are colliding directly with strict corporate governance laws, Securities and Exchange Commission regulations, and the foundational charter of the company itself. The massive legal problem is that these specific assets are almost always contractually non-transferable. The corporation issuing the wealth absolutely refuses to allow a non-employee ex-spouse to suddenly appear on their capitalization table. You cannot simply cut an executive stock option in half and hand 50% to the departing partner. If an attorney attempts a forced legal transfer, it can trigger immediate forfeiture of the asset, massive punitive tax events, and a catastrophic destruction of the very wealth they are fighting to divide. To navigate this corporate minefield, elite family law attorneys deploy highly complex legal workarounds. Let us examine a specific case study rooted in the current 2026 technology sector. Imagine an executive named Michael, a critical engineering director at a rapidly expanding autonomous robotics firm. As part of his executive compensation package, Michael holds $20 million in unvested restricted stock units. His spouse Jessica files for divorce. Because the underlying corporate agreements strictly prohibit Michael from transferring ownership of these unvested shares to anyone else, Jessica is seemingly blocked from receiving her equitable share of this massive, boom-time wealth. The company board of directors will simply not allow it. To solve this, Jessica's legal team will force the creation of what is known in elite family law as a constructive trust. This mechanism is a masterpiece of legal engineering. Under a constructive trust, the family court officially recognizes that while Michael legally retains full ownership and voting rights of the restricted stock units on paper, he is completely stripped of the beneficial ownership of Jessica's 50% share. The court essentially forcibly drafts Michael into becoming a financial fiduciary for his ex-wife. The exact legal settlement will dictate an if, as, and when distribution protocol. This means that if the stock eventually vests, as the shares become liquid, and when Michael actually sells them on the open market, he is legally mandated to immediately wire the exact after-tax proceeds of Jessica's equitable portion directly into her personal accounts. He is held legally liable to execute these transactions perfectly. If the 2026 bull market continues to rage and those shares double in value again before vesting, Jessica captures all of that future upside without ever officially owning a single share of the company. It creates a terrifying, highly volatile post-divorce reality where two former spouses, who may harbor deep resentment, remain inextricably tied together by millions of dollars of phantom corporate equity for years into the future. However, the constructive trust model is merely the baseline of complexity. We must look at the historical trends within the private equity and hedge fund sectors to see how these legal battles reach their absolute peak. Consider a scenario involving a character named Amanda, a managing partner at a highly aggressive private equity firm operating in the booming 2026 financial markets. Amanda's primary source of wealth is not a salary. It is carried interest. Carried interest is essentially a contractual right to receive a massive 20% share of the ultimate profits generated by the investment fund over a 10-year life cycle. Amanda's spouse, Robert, demands his equitable share of this carried interest during the divorce. The legal friction here is immense because private equity partnership agreements are famously draconian. The institutional investors backing the fund demand absolute alignment of interests from the managing partners. If Amanda attempts to assign her carried interest to Robert, the institutional limited partners could view it as a massive breach of contract, potentially jeopardizing the entire multi-billion-dollar fund. In this scenario, Robert's legal representation cannot rely on a simple constructive trust, because the actual future value of that carried interest is entirely speculative. It might be worth $50 million in 7 years, or, if the market crashes, it might be worth absolutely zero. Therefore, attorneys rely on a highly calculated strategy, known as the asset offset. They hire specialized forensic valuation firms to run highly complex Monte Carlo simulations, attempting to calculate the present-day net value of that highly speculative future carried interest. Let us say the forensic accountants determine the present value of Robert's share is roughly $10 million. Instead of waiting years for a payout that may never arrive, Robert's attorneys negotiate a massive, immediate buyout. They aggressively demand that Amanda surrender $10 million worth of current highly liquid marital assets, perhaps the entire primary residence, a massive chunk of the liquid brokerage accounts and physical luxury assets, in exchange for Robert completely walking away from the future carried interest. Amanda retains all of the future upside of her private equity fund, but she is essentially wiped out of all her present-day liquidity to secure that total control. This brings us to the most dangerous silent wealth killer in any high-asset divorce during an economic boom: the weaponization of tax liabilities. When massive amounts of capital are shifting hands, elite attorneys do not just look at the gross value of an asset, they surgically analyze the embedded capital gains tax trap. Consider a scenario where a couple is dividing a massive, highly appreciated stock portfolio acquired a decade ago. The gross value is $10 million. The husband agrees to take $5 million in cash from a recently sold commercial property, while the wife agrees to take the $5 million stock portfolio. On paper, it looks like a perfectly equitable 50-50 split. But the reality is a brutal lesson in financial literacy. The $5 million in cash is fully liquid and tax-free upon transfer between spouses under Section 1041 of the Internal Revenue Code. However, the $5 million stock portfolio carries a massive, embedded capital gains tax liability from a decade of massive economic growth. When the wife eventually attempts to sell those stocks to fund her post-divorce lifestyle, she will trigger millions of dollars in federal and state capital gains taxes. She did not actually receive $5 million. She received $5 million minus an enormous deferred tax bill. The husband, guided by a highly sophisticated legal team, intentionally leveraged her lack of tax literacy to stick her with the entire tax burden of the economic boom, effectively walking away with millions more in true net of tax value. The division of complex, illiquid wealth and the strategic transfer of tax liabilities require an astonishing level of financial intelligence. But what happens when the underlying asset generating all of this massive boomtown wealth is not a passive stock portfolio or an untouchable private equity fund? What happens when the primary asset is a highly active, heavily leveraged, wildly successful family-owned enterprise where both the husband and the wife are indispensable to the daily operations? How does a family court judge divide a booming corporate empire when the two architects of that empire are currently engaged in total, unrelenting legal warfare, and their mutual animosity threatens to completely destroy the very business that makes them wealthy? When a massive economic expansion collides with the dissolution of a co-owned family enterprise, the legal battlefield fundamentally shifts. We are no longer dealing with the passive division of stocks or the delayed payout of executive compensation. We are dealing with an active, breathing organism that requires constant management, cash flow, and strategic direction to survive. The divorce attorney must now navigate the terrifying reality that the sheer momentum of the 2026 economic boom is both the greatest asset and the most lethal liability to the divorcing couple. If the husband and wife are both integral operators of a thriving business, their personal warfare will inevitably bleed into the corporate culture, completely paralyzing executive decision-making, terrifying key employees, and causing lucrative boom-time contracts to evaporate. The legal machine must find a way to surgically extract one spouse from the business without killing the golden goose in the process. Consider a highly complex scenario reflective of current historical trends in the logistics and supply chain sector. Imagine two founders, Richard and Elena. Over 15 years, they built a regional distribution company. However, due to the unprecedented e-commerce explosion of the year 2026, their business has experienced a meteoric rise, expanding nationwide and generating tens of millions in annual recurring revenue. They are co-chief executive officers, equal shareholders, and they absolutely despise each other. As the divorce proceedings begin, a massive structural crisis immediately emerges. Neither Richard nor Elena wants to surrender their equity in a booming company, and more importantly, because the valuation of the company has skyrocketed to astronomical heights, neither of them possesses the personal liquid capital required to buy the other person out. This triggers a massive, highly technical war of business valuation. Elite family law attorneys do not rely on standard accountants for this. They hire forensic business appraisers who specialize entirely in litigation. Elena hires a forensic expert who utilizes a highly aggressive discounted cash flow model. This expert projects the current euphoric 2026 boom time revenue out over the next 10 years, assumes the economic expansion is permanent, and arrives at a staggering valuation of $100 million. Alina's legal strategy is to demand a $50 million buyout, knowing full well Richard cannot pay it, thereby forcing a complete sale of the company to a private equity firm at the absolute peak of the market. Conversely, Richard's attorney hires a competing expert who utilizes a normalized earnings approach. This expert aggressively discounts the 2026 revenue spike as a temporary macroeconomic anomaly, factors in hypothetical future recessions, highlights the massive key person risk if Alina leaves, and artificially depresses the valuation to $30 million, attempting to make a buyout mathematically feasible. The family court judge, who is a legal scholar and not a corporate financier, is now forced to arbitrate between two vastly different financial realities. But as the litigation drags on for months, the internal warfare begins to actively destroy the company. Richard starts undermining Alina's authority with key vendors. Alina freezes Richard's access to corporate operating accounts. The business begins hemorrhaging top talent who refuse to work in a toxic, legally paralyzed environment. When the value of the marital estate is actively bleeding out due to spousal sabotage, the elite divorce attorney deploys the absolute nuclear option of family law, the court-appointed receiver. Attorneys will petition the judge to immediately strip both Richard and Alina of all corporate control and hand the entire keys of the empire over to a neutral, third-party receiver. A receiver is a highly compensated, state-appointed corporate mercenary. Their sole legal mandate is to protect the financial value of the asset for the court, completely disregarding the emotional attachments of the founders. Once appointed, the receiver can walk into the corporate headquarters, legally terminate both Richard and Alina from their own company, freeze all their corporate perks, and immediately prepare the business for a fire sale to the highest bidder. The mere threat of a receivership is often the only psychological weapon terrifying enough to force two warring founders into a mediated settlement. They are forced to realize that if they do not compromise and divide the business themselves, the state will forcibly liquidate it for them, consuming massive percentages of the boom time wealth in administrative and receiver fees. If the threat of the receiver succeeds and one spouse finally agrees to exit, the legal team must engineer a complex corporate restructuring to fund the buyout. Since personal liquidity is rarely sufficient, attorneys will execute a leveraged spousal buyout. They utilize the massive borrowing power of the booming company itself. The attorneys will work with corporate lenders to secure a massive commercial loan against the business assets and its future boom time cash flows. The company takes on millions of dollars in new debt, and that borrowed capital is immediately used to pay off the exiting spouse. Alina walks away with tens of millions in highly liquid, risk-free cash, capturing the absolute peak value of the 2026 economic boom. Richard retains total, uncontested ownership of the empire, but he is now burdened with massive corporate debt. He is gambling his entire future on the terrifying assumption that the economic boom will continue long enough for him to pay down the leverage he used to buy his freedom. This specific transaction introduces one of the most intellectually brutal and heavily litigated concepts in high-asset family law, the paradox of double dipping. This is a highly specialized financial trap that ensnares countless business owners during an economic boom. Let us say Richard retains the business, which was valued based strictly on its massive capacity to generate future income. The court uses that future income projection to determine the massive buyout price he just paid to Alina. However, Alina also files for permanent spousal support, commonly known as alimony. The court then looks at Richard's massive, boom-time executive salary and the distributions he takes from that exact same business, and uses that income to calculate a staggering monthly alimony payment. Richard's attorneys will furiously argue that the court is legally double-dipping. They will argue that the court has already capitalized the future income of the business to award Alina her massive $50 million buyout, and now the court is turning around and using that exact same future income stream a second time to force Richard to pay a massive monthly alimony obligation. It is the equivalent of selling a cow, and then being legally mandated to continue delivering the milk to the buyer for the rest of your life. During an economic expansion, when business revenues and executive incomes are temporarily hyperinflated, the risk of double dipping becomes a catastrophic financial threat, potentially locking the wealth-retaining spouse into an indentured servitude based entirely on economic anomalies that may vanish the moment the market cools. The division of the active enterprise requires surgical precision, massive commercial leverage, and a profound understanding of corporate finance. But what happens when the legal maneuvers completely fail? What happens when one spouse realizes that the corporate bylaws, the strategic debt, and the forensic valuations are all stacked against them, and they decide that if they cannot extract the boom-time wealth they feel they deserve, they will simply burn the entire empire to the ground. What happens when the battleground aggressively shifts from the sealed, confidential documents of the private courtroom directly into the ruthless, highly destructive public arena of corporate sabotage, reputation destruction, and the weaponization of public relations? This is the terrifying threshold where high-asset family law mutates into a public relations bloodbath. When the private courtroom doors are no longer sufficient to contain the financial warfare, and when the complex legal mechanisms fail to deliver the desired boom-time payout, a highly aggressive spouse will strategically shift the battlefield. In the hyper-connected, artificially intelligent media landscape of the year 2026, reputation is synonymous with capital. For a chief executive officer, a hedge fund manager, or a high-profile real estate developer, their public perception is intrinsically linked to the valuation of their company, the confidence of their investors, and the stability of their stock price. Destroy the public perception, and you instantly destroy the underlying wealth. But elite divorce attorneys understand a far more lucrative truth. The actual destruction of the reputation is not the goal. The terrifying imminent threat of that destruction is the ultimate legal leverage designed to force a massive, immediate financial surrender. This introduces a highly controversial, legally gray maneuver known in elite circles as the draft complaint strategy. Imagine a historical trend where a highly successful executive is preparing for a massive corporate merger during an unprecedented economic expansion. The executive is entirely dependent on a pristine public image to close the multi-billion-dollar deal. Their spouse, seeking a massively disproportionate share of the marital estate, retains a highly aggressive litigation team. Instead of quietly filing a standard petition for dissolution of marriage in the local family court, which would trigger a confidential and sealed process, this legal team spends weeks drafting a highly inflammatory, profoundly damaging civil lawsuit. This document is meticulously packed with sensational allegations of profound personal misconduct, alleged corporate malfeasance, hostile workplace environments, and explosive financial irregularities. However, the attorneys do not actually file this document with the court. Filing it would make it a matter of public record and subject the drafting attorneys to potential sanctions if the allegations are entirely baseless. Instead, they utilize a terrifying legal loophole known as settlement privilege. They securely deliver this unfiled, explosive draft complaint directly to the executive spouse and their corporate legal counsel, accompanied by a very simple, highly coercive message. The message dictates that if the executive does not immediately agree to surrender a massive, non-negotiable percentage of the boom-time wealth within 48 hours, this document will be officially filed in a public courthouse, heavily distributed to national media outlets, and strategically leaked to key institutional investors. It is an act of absolute legal terrorism that operates just barely millimeters outside the legal definition of criminal extortion. To understand the sheer magnitude of this threat in the year 2026, we must examine the specific vulnerabilities of corporate governance. Consider a highly realistic scenario involving a character named Marcus, the founder of a soaring financial technology platform, and his spouse, Victoria. Marcus has secured hundreds of millions of dollars from aggressive venture capital firms who are demanding a rapid return on their investment during the current economic boom. Victoria understands that these venture capitalists possess absolute power over Marcus through the corporate board of directors. The board has a strict fiduciary duty to protect the shareholders. If the chief executive officer becomes entangled in a massive public scandal, the board will not hesitate to brutally terminate him to protect the valuation of the company. Victoria's legal team bypasses the family court judge entirely and initiates a shadow campaign directly targeting the board of directors. They strategically leak highly concerning, carefully curated fragments of information regarding Marcus and his personal stability to key industry analysts and influential financial reporters. They plant the seed of doubt. Suddenly, the venture capitalists backing the firm are terrified that a messy public divorce will derail their highly anticipated initial public offering. The board of directors calls an emergency, closed-door meeting with Marcus. They issue an absolute ultimatum. They command him to settle the divorce immediately, quietly, and at absolutely any financial cost, or they will invoke the moral turpitude clause in his employment contract, strip him of his chief executive title, and forcibly seize his unvested equity. Marcus is no longer fighting his wife. He is fighting the absolute combined weight of his own corporate empire, entirely manipulated by his spouse's legal strategy. But the weaponization of information extends far beyond internal corporate politics. In an era of intense financial regulation, the most devastating weapon a divorcing spouse possesses is the United States federal government. During a massive economic boom, when corporate valuations are skyrocketing, the temptation for executives to engage in aggressive, highly questionable accounting practices to artificially inflate revenue is astronomical. If a spouse has intimate knowledge of these internal financial mechanics, they transform from a disgruntled partner into a highly lethal corporate whistleblower. Under current regulatory frameworks, such as the Securities and Exchange Commission Whistleblower Program, an individual who provides original, actionable information leading to a successful enforcement action can be awarded up to 30% of the total monetary sanctions collected by the government. Imagine the catastrophic potential outcomes of this program during a high-asset divorce. A spouse does not simply threaten to tell a family court judge about hidden offshore accounts. They literally compile a massive dossier of internal corporate fraud and hand it directly to federal prosecutors. They intentionally trigger a massive federal raid on their partner's booming company. The stock price violently collapses, the executive spouse faces devastating criminal liability, and the whistleblowing spouse legally collects a massive, multi-million-dollar, tax-free bounty directly from the federal government, completely outside the jurisdiction and control of the family court system. It is the ultimate scorched earth tactic, allowing one partner to completely annihilate the other's boomtime empire, while simultaneously enriching themselves beyond measure. To counter this terrifying level of public and regulatory warfare, the elite divorce attorney defending the executive spouse must radically expand their operational capabilities. They no longer rely exclusively on paralegals and junior associates. They immediately deploy specialized litigation public relations firms and elite corporate intelligence agencies. This creates a parallel, highly secretive industry operating entirely in the shadows of the family court system. When millions of dollars of boomtime wealth are under threat from public exposure, the defensive legal strategy immediately becomes a campaign of mutually assured destruction. The defensive corporate intelligence firm initiates a massive, incredibly invasive opposition research campaign against the threatening spouse. They deploy private investigators to monitor physical movements, they forensically analyze decades of digital communication, and they relentlessly hunt for any hidden vulnerabilities, past indiscretions, or undisclosed financial liabilities that can be weaponized in return. The goal is to build a counter dossier so profoundly damaging that the aggressive spouse is forced into a terrifying stalemate. The attorneys meet in heavily secured conference rooms, literally trading explosive dossiers across the table, silently acknowledging that if either side actually pulls the trigger and goes public, the resulting media firestorm will completely destroy the reputations, careers, and future earning potential of both individuals. Furthermore, the litigation public relations firm works continuously to inoculate the broader market against potential leaks. They proactively seed positive, highly optimistic narratives about the executive spouse in major financial publications, actively suppressing any emerging negative search engine optimization results. They meticulously prepare the corporate board of directors with robust crisis communication protocols, ensuring that if the aggressive spouse attempts to infiltrate the investor base, the narrative has already been preemptively neutralized. The legal fees associated with retaining this shadow army of private investigators, crisis managers, and corporate intelligence operatives routinely exceed the actual cost of the divorce litigation itself, draining massive amounts of liquid capital from the marital estate purely to maintain the illusion of absolute stability. The psychological devastation inflicted by this relentless, multi-front public warfare is absolute. Individuals who successfully navigated the most brutal corporate boardrooms and engineered massive financial empires during the 2026 economic boom are systematically broken by the sheer paranoia of knowing their most intimate secrets are being weaponized for maximum financial extraction. They are forced to live in a state of constant, suffocating terror, waiting for the devastating media leak or the sudden federal subpoena that will obliterate their entire reality. But eventually the warfare concludes. The shadow campaigns are exhausted, the mutually assured destruction forces a bitter compromise, and the final, legally binding marital settlement agreement is signed. The massive boomtime wealth is permanently divided, the offshore trusts are formally dissolved, and the public relations crisis managers are finally dismissed. The divorced individuals step out of the legal machine, believing they have survived the absolute worst of the economic cycle. They believe the battle is permanently over, and their remaining wealth is finally secure. But they are tragically, fundamentally mistaken. Because the most dangerous threat to their newly divided fortune does not occur during the chaos of the divorce itself. The true hidden devastation arrives silently, years after the ink has dried on the settlement, triggered by an inevitable, ruthless macroeconomic force that neither the attorneys nor the court system can possibly control. What happens to a carefully engineered, multi-million-dollar divorce settlement when the massive economic boom suddenly violently ends? This is the phenomenon known in elite legal circles as the post-judgment macroeconomic collapse, and it is a financial nightmare that destroys wealth faster and more ruthlessly than the divorce itself. To understand this devastation, we must examine the fundamental, rigid nature of family law and how it interacts with volatile economic cycles. When a massive settlement is finalized during the euphoric peak of the 2026 economic boom, the financial architecture of that settlement is entirely predicated on a snapshot in time. The court, the attorneys, and the divorcing couple are making permanent legal decisions based on peak asset valuations, peak executive salaries, and the dangerous psychological assumption that the macroeconomic environment will simply remain stable forever. But markets do not remain stable. When the liquidity dries up, when the stock market experiences a brutal correction, and when property values plummet, the meticulously crafted legal agreement suddenly transforms into a suffocating financial prison. The first and most immediate casualty of a post-boom recession is the perceived fairness of the property division. Consider a highly specific case study involving historical trends in asset allocation. Imagine a couple, Thomas and Olivia, who finalized their divorce in the late stages of an economic expansion. Their marital estate is valued at $20 million. The settlement dictates a strict 50-50 split. Thomas, a highly aggressive portfolio manager who deeply believes in the continued growth of the technology sector, insists on taking his $10 million share entirely in high-growth, highly volatile tech stocks and concentrated equity in his own firm. Olivia, prioritizing absolute financial security, demands her $10 million share entirely in liquid cash, short-term treasury bills, and fully paid-off real estate. On the day the judge signs the final decree, the division is mathematically perfect. Then, the economic reality violently shifts. A macroeconomic shockwave hits the market. Interest rates soar, institutional capital flees the technology sector, and a severe recession begins. Within 12 months of the divorce being finalized, the tech bubble bursts. Thomas watches in absolute horror as his $10 million equity portfolio rapidly evaporates, plummeting in value to a mere $2 million. Olivia, however, is completely insulated. Her cash and treasuries are perfectly safe, and she is essentially immune to the market crash. Thomas is now facing catastrophic financial ruin and instinctively contacts his elite divorce attorney, demanding to go back to court to renegotiate the settlement because the outcome is no longer fair. This is when he learns one of the most brutal, unforgiving truths of the United States family law system. Property division is absolute and it is final. Unlike spousal support or child support, a judge cannot and will not modify a final property judgment simply because one spouse made a terrible investment decision or because the macroeconomic environment collapsed. The court does not offer a warranty on the future value of the assets you chose to accept. Thomas is trapped with his massive losses, while Olivia walks away with the entirety of the boom-time wealth perfectly preserved. However, the rigidity of property division pales in comparison to the absolute, suffocating terror of boom-time spousal support obligations colliding with a sudden economic recession. The most volatile element of any high-asset settlement is the calculation of permanent alimony. During an economic boom, when business revenues are exploding and executives are pulling in massive, hyperinflated bonuses, the court uses these astronomical figures to calculate the monthly support obligation. Imagine a character named David, an executive in the commercial lending space. In 2026, his compensation package, heavily inflated by the booming real estate market, reaches $3 million a year. Based on this peak income, the court orders him to pay an astonishing $60,000 a month in permanent spousal support to his ex-wife. When the recession hits, the commercial lending market freezes completely. David's firm undergoes massive corporate restructuring, his bonuses are entirely eliminated, and his base salary is slashed to $300,000 a year. He is mathematically insolvent. His annual income is now $300,000, but his legally binding, court-ordered alimony obligation remains set at $720,000 a year. He is bleeding capital at an unsustainable rate, draining his remaining savings just to make the monthly payments. To survive, David must initiate a highly complex, fiercely litigated process known as a post-judgment modification. You might logically assume that if you lose your job or your income drops by 90%, the family court will immediately and automatically reduce your alimony payments. This is a catastrophic misconception. The legal burden of proof required to modify a boom time support order is incredibly high. David must file a formal petition and legally prove that he has experienced a substantial, material, and entirely involuntary change in circumstances. This triggers an entirely new wave of brutal legal warfare. His ex-wife's attorneys will not simply accept his claim of poverty. They will aggressively counterattack. They will accuse David of deliberately underemploying himself, hiding assets, or intentionally tanking his own career purely to starve his ex-wife of her court-ordered support. They will subpoena his new employment contracts, depose his corporate board members, and drag him through months of grueling financial discovery all over again. While this expensive modification litigation drags on for a year or more, the original $60,000 a month obligation continues to accrue. If David runs out of liquid cash and stops paying, he enters the terrifying realm of alimony arrears. Unpaid spousal support is one of the most aggressively enforced debts in the United States legal system. It cannot be discharged in federal bankruptcy court. The family court judge has the absolute authority to garnish David's remaining wages, seize his tax refunds, place heavy legal liens on any remaining real estate he owns, suspend his driver's license, revoke his international passport, and in severe cases of willful non-payment, hold him in criminal contempt of court and sentence him to actual jail time. The legal machine transforms from a wealth extraction mechanism into a relentless debt collection agency, completely indifferent to the broader macroeconomic collapse that caused the crisis. This post-boom devastation perfectly illustrates the lethal flaw of the leveraged spousal buyout we discussed previously. Recall the founders who borrowed tens of millions of dollars against their booming company to fund an immediate cash payout to an exiting spouse. When the recession hits and consumer spending plummets, the company can no longer generate the massive cash flow required to service that aggressive corporate debt. The highly leveraged business is forced into Chapter 11 bankruptcy. The spouse who retained the company loses absolutely everything they built over a lifetime, their equity wiped out entirely by the creditors. The exiting spouse, however, already extracted the peak valuation in cold, hard, untraceable cash years earlier, entirely insulated from the corporate collapse. The economic boom creates the illusion of infinite prosperity, encouraging couples and their attorneys to construct massive, fragile legal settlements built entirely on leverage, projected future earnings, and highly inflated asset valuations. When the music stops and the liquidity vanishes, these legal structures collapse inward, crushing whoever is left holding the illiquid assets or the unmodifiable support obligations. The sheer scale of this wealth destruction forces us to confront the ultimate reality of the family law system. It is not designed to protect your wealth. It is designed to process your dissolution. So, how does a highly successful individual actually survive this systemic meat grinder? What are the precise, non-negotiable defensive strategies, the proactive legal architectures, and the exact financial fortifications that the ultra-wealthy are quietly implementing right now, long before the divorce papers are ever filed, to ensure they do not become victims of this devastating machine? To survive the devastating legal and financial machine we have uncovered, the ultra-wealthy do not simply rely on a standard prenuptial agreement drafted a few weeks before a wedding. They understand that a contract is only as strong as the court willing to enforce it. Instead, they rely on a far more impenetrable concept known as structural asset isolation. In the year 2026, the absolute pinnacle of defensive financial architecture is not about fighting over who gets to keep the wealth. It is about establishing beyond a shadow of a legal doubt that the individual facing the divorce does not actually own the wealth in the first place. If you do not legally own the asset, a family court judge cannot legally divide it. This is the realm of advanced estate planning deployed as a preemptive litigation shield. The primary defensive fortification utilized by the financial elite is the Domestic Asset Protection Trust. While we previously discussed offshore entities, the current historical trends show a massive migration of capital to domestic trust havens located in states with extremely aggressive privacy and asset protection laws, specifically Nevada, South Dakota, and Wyoming. These states have explicitly designed their trust codes to attract billions of dollars in capital by offering practically impenetrable legal walls against future creditors, and under specific legal definitions, a divorcing spouse is categorized as a future creditor. Imagine a highly realistic scenario involving a character named Alexander, a software engineer who holds highly valuable, unvested equity in a rapidly growing artificial intelligence company. Long before Alexander ever meets his future spouse, and long before the economic boom hyperinflates the value of his company, he establishes a domestic asset protection trust in Nevada. He legally transfers the ownership of his equity shares into this trust. He appoints an independent, third-party corporate trustee to manage it, while he remains the primary beneficiary. Years later, Alexander gets married, the 2026 economic boom hits, and his company goes public. The wealth inside the trust skyrockets to $50 million. When his marriage eventually dissolves, his spouse's legal team will furiously attempt to access that wealth. However, they will face a devastating realization. Because the trust was established entirely prior to the marriage, and because Alexander legally surrendered direct ownership to the trustee, the family court system in his home state has absolutely no jurisdiction over the trust corpus. The $50 million is completely legally isolated from the marital estate. It is a potential outcome that effectively neuters the highest-paid divorce attorneys in the country. But what if the wealth is generated during the marriage, in the absolute heart of the economic expansion? This is where attorneys deploy the heavily scrutinized, yet highly effective, family limited partnership. This structure is designed to do one specific thing: intentionally destroy the perceived, litigated value of a booming asset by fracturing its control mechanisms. Consider a character named Victoria, who builds a massive, highly lucrative portfolio of commercial real estate during the current economic expansion. Knowing that her marriage is inherently unstable, she does not hold these properties in her own name or in a simple joint account. Instead, Victoria transfers the entire real estate portfolio into a newly formed family limited partnership. The genius of this structure lies in how the ownership is legally divided. Victoria structures the entity so that she owns a 1% general partner interest and a 99% limited partner interest. The general partner, despite only owning 1% of the actual financial value, possesses 100% of the legal control. The general partner makes all the decisions regarding selling properties, refinancing debt, and distributing cash. The limited partner interests own the financial value, but possess absolutely zero voting rights and zero control. As the economic boom continues, Victoria quietly gifts or transfers those 99% limited partner shares into an irrevocable trust for the benefit of her children, keeping only the 1% general partner share for herself. When her spouse eventually files for divorce and demands his equitable share of the booming real estate empire, his forensic accountants run into a massive valuation brick wall. They are not valuing a liquid portfolio. They are trying to value a minority, non-controlling interest in a private partnership. Victoria's legal team will aggressively apply massive legal discounts to the valuation. They apply a lack of control discount, arguing that since the limited partner shares cannot force a sale or demand a cash distribution, they are essentially worthless to an outside buyer. They then apply a lack of marketability discount, arguing that no rational investor would ever buy into a hostile family partnership. Through this complex legal alchemy, a real estate portfolio that generates tens of millions of dollars in actual boom time revenue is artificially depressed on paper to a fraction of its true worth, saving Victoria millions of dollars in forced buyout capital. Beyond these complex structural entities, the absolute most critical defensive strategy is the rigid, almost paranoid enforcement of financial segregation. Commingling is the silent wealth killer. In community property states, an asset acquired before marriage is generally considered separate property. However, during an economic boom, the sheer influx of capital makes people highly undisciplined. If a wealthy individual owns a separate premarital apartment building, and they use just one single dollar of marital income, perhaps a portion of their boomtime executive bonus, to repair the roof of that building, they have instantly contaminated the asset. The opposing divorce attorney will successfully argue that by injecting marital capital into a separate asset, the marital estate now holds a financial lien against the booming, appreciated value of that entire building. To prevent this, the ultra-wealthy operate their personal lives with the strict, audited discipline of a publicly traded corporation. They maintain entirely separate banking architectures. They utilize specific, isolated accounts exclusively for the maintenance of their separate property, actively ensuring that not a single penny of shared marital income ever touches their protected assets. They employ dedicated personal bookkeepers whose sole responsibility is to track the exact legal origin of every single dollar flowing through the household, creating an undeniable, heavily documented paper trail that can instantly defuse any forensic accountant's attempt to claim commingling. Living this way requires a profound, often chilling psychological detachment. It requires individuals to enter a marriage, the most intimate human relationship possible, while simultaneously managing a highly complex, covert financial exit strategy. It means looking at a spouse during a euphoric economic expansion and silently knowing that the true extent of your wealth is hidden behind layers of impenetrable trusts and discounted partnerships. This is the ultimate cost of surviving the high-asset divorce machine. You protect your capital, but you permanently sacrifice the concept of complete financial partnership. Through this comprehensive retrospective, we have completely dismantled the machinery of the United States family law system during periods of extreme macroeconomic expansion. We have seen how boom-time liquidity weaponizes legal strategies, how invisible offshore accounts and unvested corporate equity paralyze the court system, and how the threat of absolute public destruction is used to extort massive financial settlements. You now possess a highly guarded perspective on the cold, calculated realities of wealth division that the vast majority of the population will never understand until it is far too late. But the legal and economic landscape is never static. It is currently evolving at a terrifying velocity. As we look ahead to the next decade of wealth creation, a new unprecedented variable is rapidly entering the legal battlefield, one that threatens to make human forensic accountants completely obsolete and rewrite the fundamental rules of asset obfuscation entirely. What exactly happens to the multi-billion-dollar divorce industry when elite legal teams begin deploying advanced, unregulated artificial intelligence to track, hide, and litigate marital wealth?